Hello everyone. This presentation focuses on the content and purpose of Civil Procedure Code. Civil Procedure Code contains rules relating to the procedure that has to be followed by the civil courts while dealing with claims under civil law, that is, under law of property, law of obligation, law of torts, or under personal law. The Civil Procedure Code consists of two parts. The first part, that is the body of CPC, consists of sections 1 to 158. This part can be amended only by the legislature. The second part consists of 51 orders and each order contains a set of rules. This part can be adopted or modified by a high court to suit the local conditions. Modifications of the second part have to be followed by the subordinate courts. These modifications should not be inconsistent with the provisions contained in the first part. What are the various steps of a civil suit? Right from filing the suit in the appropriate court to the execution of the decree, civil suit involves a number of stages. The first one is the filing of pleadings. In a civil suit, there will be two parties, the plaintiff and the defendant. The plaintiff is the party whose right has been infringed and who approaches the court by filing a suit for appropriate relief. The suit is initiated by filing of the plaint. The plaint is the claim made and the relief sought for in writing signed by the plaintiff, which should contain all the facts including the particulars pertaining to fraud, misrepresentation, willful default, etc. wherever necessary. Documents on which relief is sought or relied upon have also to be produced by the plaintiff. The other party to the suit is the defendant, who is alleged to have violated the plaintiff's rights. He files a written statement in reply to the plaint filed by the plaintiff. The plaint and the written statement constitute the pleadings in the civil case. All those who are involved in the violation of plaintiff's rights are necessary parties to the suit and hence they have to be impleaded. The suit has to be so framed as to bring out all the issues involved in the dispute to enable the court to consider them and take an appropriate decision in the matter. This would prevent further litigation concerning these issues. Documents relied upon by the parties have to be produced at the time of or before settlement of issues, and the court would endorse the documents that have been admitted, and this is called the marking of documents. The court would then frame issues for decision based on allegations made on oath by parties or their pleaders and also on the contents of the documents produced by them. List of witnesses should be furnished to the court within 15 days from the date of framing of issues. Witnesses would be examined and cross-examined and their depositions would be recorded by the court. The court may appoint commissioners to examine witnesses or accounts or scientific or technical or expert investigation or local investigation or for making a partition or for sale of immovable property. Report has to be filed by such commissioner within the time specified by the court and objections can be filed on the report. Commissioner can be examined as a witness. The parties would have to put forth their arguments on the points of law. The next stage is pronouncement of judgment in the open court to be signed and dated by the judge. The judgment has to contain a concise statement of the case, issues for determination, decision or finding on each issue, and reasons for such finding or decision. Decree is the formal expression of adjudication. Here, the rights of the parties are judicially and conclusively determined, having regard to all or any of the matters in dispute. There is a process for scrutinizing the correctness or otherwise of the decisions of the court of first instance, that is the trial court. It may be in the form of an appeal, reference, review, or revision. Appeal is the judicial examination of the decision of a lower court by a higher court. In a reference, the trial court refers the matter in which there is a doubt about a question of law for the opinion of the High Court. In a review, judicial examination of the case by the same court and by the same judge takes place. This is available only when there is no right to appeal or where the appeal is not preferred. In revision, the High Court calls for record and critically or carefully examines the matter with an intent to correct or improve the decision. The final stage would be filing of execution petition by the decree holder for the execution of the decree. It could be by delivery of property, by attachment and sale of property, by arrest or detention in civil prison, by appointing a receiver, or by effecting partition or in such a manner as the nature of the relief requires. In the interest of the state and the parties concerned, there has to be a limit to the litigation. The Limitation Act prescribes a time period within which a right can be enforced in a court of law. A statutory time frame within which a person has to initiate a legal action against violation of a right vested in him or for a breach of duty owed to him is laid down by the law of limitation. This is based on the principle that law will assist only those who are vigilant about their rights and not those who sleep upon it. Time limit for various suits has been provided in the schedule to the Limitation Act. Every stage of a civil proceedings is very important, and unless the procedure prescribed by the code is followed, the suit for enforcement of a right would fail on technical grounds, which would lead to great injustice to the parties concerned. Hence, a thorough knowledge of the rules contained in the civil procedure is a must for civil practitioners. Thank you.